So I'd like to thank you, our friends from FPF, and because of this organization, it's a really worth and informative event. So I'm really looking forward to share some impressions and information about these global trends, let's say, and how we can be informative and cooperative with each other. So I'd like also to thank you to be part of this event with Clarice, Yakov, and also Gabriela, one of our greatest global thinkers about privacy. And I'd like to start by introducing my organization. I think it's quite important because I can say what we do and what we don't do as well. So I will share my presentation. I have some here, some slides. So let me see. Yes. So I'm executive director of Data Privacy Brazil. Data Privacy Brazil is a space of articulation between two organizations. The first one is Data Privacy Brazil School or Academy. So we are delivering professional course about privacy, data protection, and governance of emerging technologies. And also Data Privacy Brazil Research Association. So a non-profit organization that are conducting theoretical and also empirical research about privacy and data protection. And today I would like to share some thoughts and the results of one of our research, which was precisely about legal grounds at LGPD, the Brazilian Comprehensive Data Protection Law, specifically about legitimate interests. So here in Brazil, I can already say, we opted to have legitimate interests in equal foods as consent and other 8 legal bases for non-sensitive data. So we decided to move on. So as far as I could understand, it's quite different that we have right now in Israel and that you are trying to enter in a modernization process. So what we have here, Brazil developed our comprehensive data protection law. So it was a long journey. And here in almost a decade, so 10 years of discussion and public consultations of our LGPD, we have a lot of policy making and normative learnings that I would like to share. Our report was translated for English with support of our friends from FPF. So I think you have already access. And the report and my presentation will be divided in 2 parts. So first, what was the path to create and to craft legal grounds at the Brazilian Comprehensive Data Protection Law? So what was our policy-making learning? And after, in the second part, I'd like to share with you some controversial interpretations of our law right now with regards to legitimate interests and other legal grounds. So beyond to approve a law, there is also a second wave in order to better interpret, calibrate the meanings of the law. So I'd like to share those 2 parts of our current situation here in Brazil. So with regards to the path to craft legitimate interest as a legal ground, and also to shift the normative design of our Brazilian Comprehensive Data Protection Law. So there is a really worth and informative timeline here in Brazil, because as I just said, we had like 10 years, almost 10 years of public discussions, several draft texts that was put in an open public consultation. And since the beginning, we could see how the text evolved. So until 2015, between the first public consultation and the second public consultation, consent was the main hypothesis as a legal ground, like the rule. And the Brazilian civil society decides to evolve the text. Also, who was working at the government at that time that was creating and crafting the text of the draft bill. After these 2 rounds of consultations, then we decide to include legitimate interests as an additional legal base. And we have here a long journey and several disputes that happen. And I think it's really worth to share with you. First of all, I think here in Brazil, we could learn with our regulatory delay and also doing some research about what was and what is the state of art of legal grounds in other jurisdictions. And one of them, of course, is the European one. As Gabriela said, legitimate interest is not new, was crafted in the directive, so almost 20 years ago. And since the beginning of the directive, because of the fragmentation of the enforcement of law, we could see that there was a lacking of a more consistent and a harmonized approach in Europe. For instance, France interpreted legitimate interest in one direction, Germany interpreted the legitimate interest in another, in a completely different direction. That's why the Working Party 29 decided to issue those guidelines in order to better calibrate the interpretation of legitimate interest. That's the whole idea behind what is called legitimate interest assessment, which is a kind of test that sets parameters in order to have predictability of how to interpret and also how to be used legitimate interest as a legal ground. So since the beginning, we could see that legitimate interest is a really open legal concept that probably will be have several interpretations. And then here in Brazil, we could see how the Brazilian civil society has read those guidelines, but also did a lobbying in the parliament to better craft legitimate interest as a legal ground. So what was the result, the balance of this process? On one side, the private sector was lobbying for legitimate interest without some kind of parameters. On the other side, NGOs was fighting of not having legitimate interest as a legal ground because they argue that would be a blank check, that would be abused and so on. At the center of this pendular movement, there was us as an academics. It's important because you have to strike a balance between protection of fundamental rights and liberties, but also the economic use of data, which is quite important for research, for innovation, and so on. So why not internalize observer legitimate interest as one of legal grounds, but put in the text, in the hard text of the law, not in the guidelines, not in recitals, but create a specific article to set the parameters in order to have a more predictability of how to use and to interpret legitimate interest as a legal ground. And recently, we published an article, an essay in this book of the CPDP conference that tells this history and this lobbying movement between not only legitimate interest, but as the law itself. So I think it's also worth if you could take a read afterwards. So the result of this process, I think it's quite worth, because then we have here in Brazil what we call it a normative equation of LGPD. So it's a little bit different in comparison to GPR. We not only have legitimate interest as a legal ground, but to have a dedicated and a specific article that sets the parameters of its application. And also we have a specific article that reinforces the legal recording process, which we think and we believe, we are advocating for this kind of interpretation, that when you are using legitimate interest, you have to have a specific record, and this specific record is legitimate interest assessment. So if you are going to use legitimate interest, which is a kind of bonus and gives a lot of discretionarity for data controllers and so on, you have to render a more intensified account about it. So I think we had this normative balance that puts in a more simple way. When we are using and we are moving the other 9 legal grounds, you have just to have a simple ROPA or records of processing. But when you are using legitimate interest as a legal ground, you have to have a different kind of accountability mechanisms in order to better precise how the organization is striking this delicate dance between liberties, fundamental rights, and economic use of data. And here in Brazil, we have this specific article, which is Article 10. So we have like 4 phases of this text, this test that try to strike the balancing between economic use and also liberties and fundamental rights. And here we are waiting for the Brazilian Data Protection Authority to decide if this is a mandatory way to handle an accountability mechanism when legitimate interest is a legal ground or not. So there is this kind of dispute, controversial interpretative point of the law right now. And then we have another kind of controversial issue, which is some data controllers are interpreting the law even in a higher cost of compliance than just having legitimate interest assessment. Because when we passed the law, the text, there was a kind of mistake. And then here, some data controllers are always using data protection impact assessments to handle an account about legitimate interest, which I personally think is wrong, because it's not the legal grounds that defines if the data operation and the data flow is riskier or not. Okay, you can have data protection data flows which is based on consent and is even riskier rather when you are using legitimate interest as a legal ground. So we are also waiting for the Brazilian Data Protection Authority solve this controversial question. What kind of accountability mechanisms is necessary when organizations are relying on legitimate interest as a legal ground? So we were able to craft a specific article to set the parameters, but right now we are waiting for a definition and a legal, let's say, security in order to be able and to be precise about what kind of accountability mechanism is necessary or not. And the second controversial issue here in Brazil is about the limits about the legitimate interest, because our law does not say anything about the right of opt-out. In other words, when the data subject can also revoke her or his consent, but maybe he or she can also impose some limits, oppose with regard to some specific use of their data when there is another legal ground for it. For instance, in GDPR or even in the European Union, there is this kind of absolute right of opt-out with regards marketing purpose for data processing. Here in Brazil, we don't have a similar provision. So here we are waiting for this clarification of how interprets the law. So like in really few words, and then I conclude here in the interest of time. I think here in Brazil, there was a really informative journey about how to involve the law in order to strike this balance. And this is quite necessary when you are crafting the regime or the menu of options with regards to legal grounds. And consent is not definitely, let's say, the pillar of the system, but it has to be like a more clear way about this interplay between consent and other legal grounds. Brazil has adopted, let's say, a creative way to not only absorb legitimate interest as one of the legal grounds, but also try to dedicate a specific article to set the parameters, which is good, I think, for not only data subjects, but also for business that controls, because then you have set a more predictable way of how to use and how to be enforced the legitimate interest in the future, which is at the end of the day about legal security, predictability, and so on. So I'd like to thank you again for having me. I hope that this presentation was informative for this really exciting process of modernization of Israel data protection law.
Thank you so much, Bruno. It certainly was, and I have a few questions, I think, in follow-up to all of you privacy experts, in line with what you just said, focusing on legitimate interest and on the fact that one of my takeaway is that it needs to be well-defined and accompanied by guidelines or a specific articulation of what is required in order to achieve a proof of legitimate interest. And one of the things that was popping up for me is if you can tell us a little bit about how do you work out the right to object to processing of data in instances where the lawful ground is legitimate interest. Then how does the person know, and can they object? How does those two pieces come together? Feel free to jump in.
I will jump in here first because I wanted to make a point that I forgot to make in my first presentation, and then I know Bruno will double down on that. It's very important to know that even when personal data is being processed on the basis of legitimate interest, so therefore you are not asking for the consent of the individual, all the other safeguards and rights still apply, for example, you still have to give notice to data subjects and find a way to with reasonable means, of course, and when it's reasonable, to find a way to give them notice and have their right of information being thus complied with. Most of the rights of the data subject continue to apply just as well for legitimate interest under the GDPR, though. For example, the data portability is not a right that's available right now for individuals whose data is processed on the basis of legitimate interest, but all of the other rights are. So you still have the right to access your own data and receive a copy of it. You can object to the processing. More than that, the other principles still apply. Purpose limitation, data security and confidentiality, and the principles in Article 5 still apply. So it's really not a safe harbor type of thing. It's quite thoughtful and complex to be able to justify it, as Bruno was pointing out. And then once you achieve that, you still have to go through the information and giving notice process and allowing data subjects to exercise their rights. And I'll stop here.
Thank you. In our last few minutes, maybe another question that I was meaning to ask all of you. How does legitimate interest work with third parties? So when we have legitimate interest that is directly by the controller, that is maybe easier to understand, can the controller work out a legitimate interest of a third party, a fourth party? How does that work?
Well, in theory, yes, it's right, because this is how the provisions are crafted, and the legitimate interest of a third party is being considered. I would even say that even the legitimate interest of the like a societal legitimate interest, a bit broader of a community, is also considered for some of this processing under legitimate interest. So the third party can actually be a community, right? If you can properly justify it. So I see that Bruno wants to intervene, and I want to.
Yeah. So with regards to your first question, Limor, I just pointed out that is one of the biggest controversial issues right now here in Brazil. We are waiting for the Brazilian DPA issue some guidelines or anything. What can I say? Definitely, the right of opt-out is not like an absolute right. So it will have to be strike a balance. In some case, it's not possible to exercise. For instance, when we are dealing with fraud prevention, doesn't make any sense the right of opt-out here. But in other case, makes like perfect sense. For instance, with regards marketing purpose. That's why GDPR established that would be, in that specific case, an absolute right. And then here in Brazil, there is this WhatsApp case that is being conducted not only by the Brazilian Data Protection Authority, but also for the Consumer Watchdog, the Antitrust Authority, and also for the Federal Public Prosecutor's Office. And they designed, they issue a guideline about the importance of transparency safeguards, because okay, if you are relying not on consent but legitimate interest for this new kind of type of using with regard to that specific of platform, at least the data subject should be the right to oppose. I would like to keep going using, for instance, WhatsApp when the economic business model was completely different. For instance, that is the message behind of the scenes. And the second, here in Brazil, there is also this provision about the legitimate interest of third parties. And I completely agree with Gabriela. I think it's something quite useful for society. So think about open data policies. So I can do the download of the whole database and then try to innovate, create new uses. I don't have any condition to go to the data subjects of 1 million of users and ask for consent, but maybe I have a proper legitimate interest to do it. So here, I think it's a quite interesting issue, because then we can think about data as a common good. And then the society can have also the proper mechanisms to innovate about it. So that's why it's so important what Gabriela said at the first part of her talk. Data protection is like a twofold mechanism. It's not only about protecting liberties, fundamental rights, but also about a free flow information of interest, of public interest in the society as a whole.
Oh, thank you very much, Bruno. That's marvelous. And Clarice, do you want to give your last sentence? And Jacob, in the last 2 minutes.
It's a very short time, but first of all, yes, in Asia as well, in the jurisdictions that implement legitimate interest, it's very clear that a wider societal interest can constitute a legitimate interest. So it goes beyond the interest of the organization that collects the data. In any case, in Singapore, it's been made extremely clear. But there will always be variations also between countries on how the legitimate interest will be assessed, in the same way that there will be differences, to assess the frontier between data protection and freedom of information and archiving law. I mean, it's always a national balancing test, right? But it is possible. And I hijacked the last question to say that to Jakob as well, that beyond the GDPR, there are also national provisions at the national level that implement the regulation further. And archiving purposes definitely are specified, and national legislations do provide a lot of detail on what is communicable, what is not. So if there's interest, I'm happy to share, at least for French law, and I know where I can find that. Thanks.
Yakov, last comments.
I just want to reiterate what I said before. Notwithstanding that everything that has been said here is compelling and probably true and so on and so forth, time plays a crucial role. As I used to say when I was in these arguments, in the 23rd century, 100% of what's in the archive from the 20th century will be fully open. Now the question is, what happens between the beginning of the 21st century and sometime in the 23rd century? But the principle is that eventually, and as time passes more, this is more and more compelling, everything, whether the individuals wanted it to be open or not, whether their relatives and their living relatives want it to be open or not, eventually everything is open totally and fully. And I mean, except what is never collected, of course, that's a different issue. So any legal system which is dealing with these crucial issues of protecting our data today must take into account the scale of the advancing time. Because what is true today is less true 20 years from now, and what is true 20 years from now is less than 50 years from now, and 100 years from now, and that scale has to be brought into discussion.
Thank you so much. So I want to thank all of the speakers, Bruno, Clarice, Gabriela, Yakov. Thank you so much for your valuable contributions. It was fascinating for me, hopefully also to our audience. We're having our next session a week from now, next Wednesday. Please know that it's an hour later. It's going to be 3 Israel time and not 2. Looking forward to seeing all of you. Thank you all speakers, and have a wonderful rest of your day, evening, night. Bye-bye.
Thank you so much.
Bye-bye. Thank you.
Thank you so much. Happy?